All right, I think a lot of people are still joining, but we can get started with today's webinar. So welcome to today's webinar on the CSDDD final agreement after a lot of drama and back and forth on the negotiation table. Last Friday, the Co-Repair representing the member states on the council level agreed to a final compromise version of the CSDDD, and we will spend today's webinar to take a look behind that final version and the changes that were made. I'm joined by Greta Koch and Sebastian Rünz. Greta, can you go ahead and introduce yourself to the audience?
Yes, sure. So I am the assistant of Axel Voss, who's a member of the European Parliament, and he's also the shadow rapporteur for the Due Diligence Directive. So I have essentially been working on the Due Diligence Directive already for the last 4 years. I drafted the EPP position, and I also led the technical negotiations on the file.
Excellent. Great to have you, Greta, again. And Sebastian, a long-term guest.
Yeah, thanks, Harald. I make it short. So my name is Sebastian, and I'm a lawyer at Taylor Wessing in our Düsseldorf office.
Great. So yeah, a few logistical points before we dive in. The webinar is recorded. We will share the slides and the recording afterwards with everybody that signed up. We have the Q&A section ready here in Zoom. You can already start asking questions during the webinar. We will try to pick up these questions if they make sense, and if not, then answer them at the end of the webinar. The agenda for the webinars is as follows. We will go point by point through the major aspects of the CSDDD final agreement, from timeline and transposition all the way to climate plan and financial sector. And we will then have a short look at the implementation timeline. So what should companies now start with as a next step with their CSDDD compliance journey? And then we will hopefully have plenty of time for Q&A. And with that, we will kick it off. And the first thing that we have prepared for you is an updated timeline, which already includes some of the major changes. Yeah, Greta, since you have really been deeply involved in that process, maybe you can run us through the last weeks after the trilogue negotiations and also what's ahead, what's still in front of us before the CSDDD is really in force.
Yeah, so officially we finished the trilogue negotiations, which are the negotiations between the Parliament and the Council to come to a common position in December. But afterwards there were several hiccups on the way because the Council intended to adopt the position that we had negotiated in December, and then there were several delays because a lot of member states had raised concerns over what was now in the text. And these concerns have been suddenly resolved last week. I have to say that I was surprised by that. But there were a couple of rather large scale changes also to the scope, which we will walk you through throughout this webinar, which led to the fact that several member states then changed their position from an abstention to a positive vote. And therefore the text was then adopted, at least on the technical level of the Council. We adopted the text in the Parliament this week in the relevant committee, which is the Legal Affairs Committee, with a large majority. And there will be another vote on the 24th of April for a plenary vote in Strasbourg, where we also expect that it should go through with a large majority. The problem that we're facing right now is, however, that we are quite late in the term of the European Parliament because the elections are coming up. And so it is likely that we won't vote on the official final position of the text because we don't have time to give it to lawyer linguists and then also to let it translate into all the official languages of the European Union. So there is still a possibility that we have to vote it again on the official version in the next Parliament, and then the Council has to approve again. So we can't for sure say right now when we actually have the entry into force of this directive. It could be sometime in May or June of this year, or it could be much later this year in maybe even December. But depending on how it goes with the translation, this will affect the entry into force.
And still in the plenary vote and in the upcoming procedures, can we now expect still some changes? How likely or unlikely is that from your perspective?
It is impossible to change the text now. What can happen, of course, is that it could be rejected by the new parliament or by the council. But I think that the risk of that is also not very high at the moment. Although, of course, I have been wrong about these kinds of things. But at the moment, I would say there might be a delay, but no further text changes.
Mhm. And yeah, maybe Sebastian, maybe you can run us through what will happen with the German Supply Chain Act, and how will then, let's say, the process after the CSDDD enters into force look like?
Well, so for the moment, we still have the German Supply Chain Act, and it will take some time until we have a final CS3D that entered into force. So for the moment, we don't have any news on, for example, the report under the German Supply Chain Act that you could skip it, for example. So you still need to file a report to BAFA. When the CS3D enters into force, is transposed into national law, then the German Supply Chain Act will be adapted to the CS3D. So in the end, we will not have two laws. We will just then have the CS3D that is also applicable in Germany, and no German Supply Chain Act anymore.
And then we have a phased, let's say, rollout application of the CSDDD. That's something we will look in more depth on the next slide. What's also notable, which I would like to mention, is the CSRD, and there's also a question about it that we already see. How does the CSRD interrelate with the CSDDD? That is also something we will answer at a subsequent slide, but maybe just as a short summary, the CSRD will be the report that companies need to file also for the CSDDD. And as we can see, it's actually applying to a much broader scope than the CSDDD ever will, and also sooner than the CSDDD comes into force. But obviously the CSRD requirements are different, also when it comes to sanction regimes and the due diligence obligations that are placed on companies. But now let's have a deeper look at the scope of application, which is, I believe, actually the place where the most severe changes were made to the law. And maybe Greta, you can quickly explain what exactly happened and what changed there.
Yes, so especially the larger member states that already have laws, especially Germany and France, but also Italy, requested that the scope of the directive was much more narrowed. So what we have now is still a cascading timeline, but we are only targeting the largest companies in Europe. So the overall scope of this directive is that companies are covered if they have more than 1,000 employees and 450 million in turnover. This cascading principles you can see here now. So 3 years after entry into force, which depending on the date of entry into force would probably be 2027, is for the very largest companies with more than 5,000 employees and then 1.5 billion in turnover. Then the year afterwards, which is 4 years after entry into force, you have those with 3,000 employees and 900 million in turnover. And then lastly, 5 years after entry into force, you have the actual scope of the directive, which is 1,000 employees and 450 million in turnover. You also see here how many companies are covered. These are the numbers that we received from the Commission, which would say that within the European Union, you cover 5,300 companies, which is quite different from the scope that we presented earlier to you in January, where it would have covered 15,000 companies in Europe. However, we also have to say that there are two exceptions to the scope. One is that parent companies are covered as soon as as they reach these thresholds on a consolidated level. So a parent company where the group of companies reaches the thresholds of 1,000 employees and 450 million in turnover is automatically covered and is also responsible for all of their subsidiaries. And there is another exception for franchising models. We call that the McDonald's case because we're not sure it targets anyone else. But there are specific franchising models where they generate a lot of turnover through royalties of vertical agreements, and these are also covered. These exceptions are not yet included in the numbers you can see here, which says that it's 5,300 companies in the EU, but we should get the final numbers soon.
Something we also show here is the application to companies that are outside the EU. Can you quickly explain, Greta, how that works? And is it true that at this point we really don't know who these companies exactly are? When will it apply to them and in which way?
Yes, so non-EU companies are covered if they generate 450 million in turnover inside the European Union, so in the single market. There's no employee threshold for non-EU companies because it's really just about the turnover that they generate inside the EU. They also have a cascading principle here that only focuses on the turnover. We do not know how many companies would actually be covered. We have asked the Commission several times for these numbers, but unfortunately they only have an indicative list of which companies could be covered. So I think it just takes time for them to collect the data. I guess in some way they said it's impossible to know the exact number when it comes to non-EU turnover generated inside the EU. But yeah, I do hope that the numbers would come soon. So far, we can only guess.
Another point I think we can mention is the high-risk sector approach has been now removed, which was previously applied to certain high-risk sectors like the construction industry and other industries where the thresholds were even lower. I think that was also a major political point raised by some of the member states. Sebastian, do you want to add anything to the scope of application?
Maybe just to the last point here on the slide, the parent company attribution. So this is very similar as in the German Supply Chain Act. So if we have an ultimate parent company falling under the CS3D, if certain prerequisites are met, which is similar to the German exercising decisive influence, then it's basically the parent company that can implement the CS3D for all the subsidiaries. And it's not the subsidiaries that maybe reach the thresholds on their own that have to like each and every one of them doesn't need to implement the CS3D. It's basically then the parent company who provides guidance in the implementation process.
So to sum up, the CSDDD differs also from the German law in that both criteria must apply. So it's 1,000 employees and more and 450 million in turnover. And that gives us reason to assume that the number of companies that now fall under the CSDDD in Germany is lower than under the German Supply Chain Act. But there's also scenarios through a parent company attribution where companies that maybe were not previously under the German Supply Chain Act could be covered by the CSDDD. Is that correct, Sebastian?
Correct. Yeah. And maybe because we were talking about both these thresholds, employees and turnover, when we look at companies located outside the EU, then we do not have in the CS3D the employee threshold, then it's just the turnover threshold.
Okay. All right, we see a lot of questions to the scope of application. We can't answer them all, but we try to get to them at the end of the webinar. Obviously, this is one of the most relevant topics to everybody at this point. And I'm sure it won't also be the last webinar that we have on the CSDDD. But moving on to another point of contention on the political level, which is the civil liability. Maybe Greta, you can explain, first of all, how the civil liability under the CSDDD actually works, and also what has changed in the most recent text.
Yes, so what we say in the article on civil liability is that companies should be held liable if they caused a damage that is connected to their risk assessment. So only if you directly yourself caused the damage, you can be held liable. This, of course, is a basic principle in most member states already under civil law, that if you cause damage, you can be held liable. There is, of course, this question of who defines whether I caused it or not. The definition of the causality will be done still within member state law. So for German companies, the German civil code will still prevail. The only thing that we very clearly say in this directive is that you cannot be held liable if the damage was caused by someone else. So we rather limit existing law from other member states, saying that you cannot be held liable unless you caused the damage yourself. There are other articles connected to the civil liability which were changed in the last weeks. These are the so-called access to justice measures, which were to make sure that the victims of damages caused through corporate practices actually have access to the justice under European law. And so we said that there would be a limitation period of at least 5 years. This is indeed different from German law, where it previously was 3 years. And also there was the clause that said that victims can mandate NGOs or trade unions to bring their cases to court. However, they can only do that if it's really directly mandated by a person, which actually limits, for instance, environmental cases, because previously you could also, as an NGO, go to court in some member states on behalf of the environment. This would not be possible under the due diligence directive. And you can only do that if the NGO is in a European member state and has been situated there for a long time. And so, yes, in that instance, NGOs can bring cases into to court, but only also if the member state actually allows that. This is unfortunately not a very harmonized approach to civil liability, but that's because under European law, you cannot really harmonize civil liability cases as such. This is a very sensitive topic for member states. So in the end, the clear definition has to come from the member states. We're just trying to give a direction to it.
Sebastian, maybe you can quickly explain how does this compare to the German law? Here we say civil liability is not included in the German Supply Chain Act. Maybe you can quickly explain it.
Yeah, that's a good but also complicated question. Because to me, the civil liability under the CSDDD is kind of a black box. And Greta, you and I know maybe we are of a different opinion, or maybe let's say you are pretty much sure that it's very similar to the German Supply Chain Act, the liability under the CSDDD. I'm not that sure. Why is that? Because the German Supply Chain Act explicitly forbids in Article 3 that a violation of a due diligence obligation causes any liability under the Supply Chain Act. This means that there could be civil liability under German law. However, then the violation of a duty would have to be outside the LKSG, outside the German Supply Chain Act. So you cannot argue that a violation of a due diligence obligation causes liability, but maybe you under general German law of tort, you find, let's say, a duty to ensure safety precautions. And this duty to safety precautions basically would lead to a liability. But the room for this is to argue with this is really small. And under the CSDDD, we do not have such an explicit exclusion of civil liability. we have a liability clause, but you're right, it says that if somebody else causes the violation, the damage, then you're not liable. But still, in the end, you could say, well, you are partly liable or jointly liable, although joint liability under the CS3D, it's explicitly mentioned that this cannot be used as an argument to come to a civil liability. But still, in the end, you could say, well, there has been another causa, but the fact that you haven't put in place policies with your contractual partner, the fact that you haven't conducted audits, the fact that you haven't taken other preventive measures can be considered as a partly causation, which in the end leads to a liability. I think it will be very interesting what courts make out of this, because they have some room with this new clause on civil liability within the CS3D to argue the one way or the other. I understand that in particular, due to the latest changes, the intention was that the civil liability is only limited to exceptional cases. But still, I'm not really sure what courts will in the end make out of it.
So, as I understand you, this is a case where there is some flexibility on the interpretation of the various phrases, and we will see in the first court cases how the judiciaries actually interpret them, and that might actually differ also from decision to decision, right? Yeah.
Correct. And in particular, it will be interesting to see when are the courts of the opinion that you caused a certain damage, if there is another causa. Is it only in exceptional cases where it is really clear that there has been this German company that also caused a damage? Or could it be like a small percentage of causation that is already enough to lead to a civil liability of a German company? We don't know that at the moment.
All right. I think,
and maybe one more thing to add, or Harald, I don't know whether you wanted to talk about the other sanctions that are.
That's exactly what I wanted to wrap up. So yeah.
Okay. Yeah.
Go ahead, Sebastian.
Yeah. Yeah. It's worth mentioning that the trade bans were deleted. This is probably due to the forced labor regulation that will enter into force. I think there is a transformation period of 3 years. And what does it say? It says products that are connected with forced labor cannot enter the European market. So we basically have an exclusion of trade bans here in the CS3D, but with respect to forced labor, we have a different regulation that basically touches on that. And also interesting that there is so much discussion about the CS3D and less discussion about forced labor prevention, because when you look at this regulation, you can see that it also contains provisions that basically lead to due diligence obligations of companies. So it's not only the CS3D that requires companies to do due diligence obligations, to fulfill due diligence obligations in their supply chain. It's also included in the forced labor prevention regulation.
Mm-hmm. All right, and the forced labor regulation will come into force. We expect it to be passed this year. Will come into force then in 3 years. That's
correct.
Okay. Maybe quickly summarizing the due diligence obligation, since nothing has changed on those. There is generally on that level strong parallels also to the German Supply Chain Act in terms of the overall obligations. And just again to mention the point, the Article 11 on the reporting and public communication. This is where the CSRD comes into play, and the CSRD will be the report for the CSDDD obligations going forward. Maybe a question to Greta or Sebastian. Are we expecting adaptations to the ESRS standards then going forward that are already published by the EFRA community to encompass more of the criteria of the CSDDD, or is that something that still remains to be seen?
That is something that remains to be seen. I mean, the ESRS standards right now, the development is very, very slow. They are mostly focusing on trying to get the sector-specific guidance out right now. But of course, the due diligence directive has an effect in terms of how to define the supply chain. And so I think that the ESRS in some form will be adapted, but we haven't had that conversation with EFRAG yet. A lot of the conversations also, I see a lot of questions on how will the German government adapt the German Supply Chain Act. It's very difficult to answer these questions at this moment, since last week we all expected that we wouldn't even have these kinds of questions. There needs to be a bit of patience with some questions on how to move forward.
All right, and let's move on again to a major point of difference, let's say, between the German and the Supply Chain Act and the CSDDD, which is the scope of the risk assessment, where on the CSDDD, already during the trilogue negotiations, the term value chain was replaced by the term chain of activities. And now, Greta, there's also been some further changes on the definition of the chain of activities. Maybe you can walk us through those.
Yes, so chain of activities is essentially just a word in order to have a compromise between those arguing for the word supply chain and those arguing for value chain. But it's more important about what's actually in the definition of the chain of activities. And I would say the upstream part is essentially the supply chain. So you should trace your product from the extraction of raw materials to the finished product, depending on where you're situated in the supply chain. But we had a long discussion about downstream, and downstream now was also further limited. So when it comes to downstream aspects, companies now have to trace their storage, their transportation, and the distribution of the product if this is done by a company directly on behalf of your company. So only if it's a direct relation and you have specifically ordered that transposition, storage, or distribution. Beforehand, we also included the disposal of the product and also the recycling of it that was deleted. And also we were talking about transport, storage, and distribution. If this was done indirectly on behalf of your company, this was also deleted. So now we really only have direct relations relating to transport, storage, and distribution of the product.
Mm-hmm. Sebastian, maybe you can quickly explain also here the difference between the German Supply Chain Act and the CSDDD.
Well, the most important difference is when you look upstream at the indirect suppliers, because that's basically something that is only covered under the German Supply Chain Act in cases of substantiated knowledge. And under the CSDDD, as long as you have a risky supply chain and where adverse impacts are likely and severe, then you would also need to look at the tier N level, not only the tier 1 level. As since Greta just explained that there have been some more limitations on the downstream side. Now the downstream side on under the German Supply Chain Act and the CSDDD are very similar. So major difference is really at the tier N level.
Mm-hmm. So let's say dive a bit into the definitions of the chain of activities as they relate to the upstream and the downstream parts. I think these are definitions that will be very crucial to also the scope of risk assessments and which suppliers companies will consider going forward. And they do deviate from the definitions also in the German Supply Chain Act. Maybe Greta, you could explain or run us through these definitions for upstream and downstream and what's important to understand about them.
Yes, so as I said, it's essentially the upstream supply chain from the extraction of the raw material. Of course, there can also be upstream transport, manufacture, and storage there. So whenever something is transported to you that is different from your downstream relations, we included the design of the product, which essentially is about, I think this is mostly about product safety, which is already covered extensively by other EU law. But this was included in order to ensure that, there can also be in very specific sectors, there can also be risks to the design of the product if we're, for instance, talking about cyber security and all these kinds of things. This is why we added design here. But other than that, I hope that, things like extraction and sourcing should be quite straightforward, as they are also the same things as the German Supply Chain Act. And then, as I said, with downstream, you only have to focus on direct distribution, transport, and storage. You don't have to check anything that's connected to sale or any B2B or B2C customer relations. This is excluded. And also we very specifically excluded any products that are already under export control, such as weapons and those falling under the dual use regulation. This is, for the weapons sector, this is relevant.
So I think from the definition on the chain of activities, the bold part that we highlighted here, is related to the production of goods or the provision of services, is where we can really argue for this difference between the German Supply Chain Act, where that kind of a definition is not there. And going back to the cases of now looking at a few sample suppliers, a case study, business partners of a large multinational manufacturing company, would we now consider those as part of the chain of activities or not? We have legal services, so the company is procuring legal services. The company is procuring coffee purely for the kitchen and the coffee machines that the employees use. The company is procuring call center services in India and batteries for their widgets or products out of Vietnam. And I think here, based on this definition of the suppliers or these upstream business partners being related to the production and the provision of services, we believe that ruling out the coffee in the kitchen is, let's say, clearly warranted. The legal services are already in a gray area. So are legal services that the company procures required for them to also provide the services and products on the market? That can be argued maybe either way, maybe also depending on the context of the company. But maybe, Greta, can you help us, maybe, since you were part of the legislative process early on, what's the intention of the law? Is the intention of the law to have the coffee in the kitchen in scope or out of scope?
So indeed, apparently the text was not clear and is still, to some people, still not sufficiently clear on what was intended and the intention of everyone. That's also, we had this discussion then also with the OECD and so on. So also under international standards, the intention was never that if you're a company that sells a specific product that has nothing to do with coffee, but you consume coffee during working hours, this should not be covered as part of your supply chain. I guess this could maybe, depending on how we would have defined a value chain, this could have been an intended consequence, but definitely not under the due diligence directive. I do think that just saying that anything that is related to your product still has some form of a gray area. So I think there are some cases where it's difficult to specifically answer whether this already falls under the directive or not. But I do hope that the fact that we have a very, very clear risk-based approach and should already lead you to not having to check every single thing that might be related to your product or not. For instance, legal services in Germany, I think you could argue that this should not fall under the risk assessment because there are no likely risks there. So we do hope that we can salvage it like that. And in addition, I think the implementation in the member states and the Commission guidelines should also shed more light on that discussion. But in the end, the intention is that you should really focus on what is related to your product, directly related to your product or the product itself, and not everything that is happening in the company that is, selling it.
Mm-hmm. Mm-hmm. And similar to Germany, where the enforcement authority released several guidance documents, can we expect a similar process on the European Union level? And might those guidance documents then clarify some of these still gray areas that we are expecting or seeing currently?
Yes, so the Commission is tasked with drawing up guidelines that basically cover the entire due diligence process. So we very clearly say that they should define the risk factors that companies should look at. They should define how to do a risk assessment. They should define which measures companies should actually use in order to mitigate their risks. They have guidelines on how to do your stakeholder engagement. So the Commission should come up with these guidelines within the next 2 years, ideally. We said 2 years after entry into force. Sometimes this is delayed, but let's hope for the best that within the next 2 years, very clear guidance that is similar to the OECD framework is produced also by the Commission for companies to have a very clear answer on how to navigate through this law. In the end, of course, the law itself is a very holistic approach, so it's difficult to take the specificities of every sector into account, which is why the guidance should be more clear.
Great. And maybe Sebastian, back to you again on the risk assessment approaches. I think the CSDDD departs also in the clear emphasis on a risk-based approach, I think, which is quite welcome from the perspective of companies covered by the CSDDD. Maybe you can explain the differences on the risk assessment approach between the German Supply Chain Act and the CSDDD.
So sorry, I was answering a lot of questions, but as soon as I answered one question, 3 more pop up. No, we still have 90. Under the German Supply Chain Act, risk analysis basically means that companies are currently looking at all their direct suppliers, whether it's direct purchasing or indirect purchasing. You basically look at all your direct suppliers, tier 1 suppliers, and tier N suppliers are only assessed if you have substantiated knowledge that a human rights violation appears possible. So most companies right now, they definitely focus on the tier 1 suppliers, and only in cases they received, for example, via their complaints procedure, a report, then they also look at the tier N suppliers. So that's the approach under the German Supply Chain Act. The approach under the CSDDD, it's maybe a little bit or very different depending how you define it. So it's more risk-based, meaning that you do not have to look at all your tier 1 suppliers. You have to do a scoping first. You have to verify where are adverse impacts likely or severe, and only at those suppliers you need to do a deep dive and an in-depth assessment. And the second filter is you only need to look at the parts of the supply chain that are basically related to your production or to the provision of your services, meaning that indirect procurement to a very large part, still there will be some arguments on whether the entire indirect procurement falls outside the scope or only partially, but a very large part of this indirect procurement is not covered by the CSDDD, meaning that in the end, you can really focus on your high-risk supply chains. In that case, of course, you need to look also at your tier N suppliers. You have to make transparent the deeper supply chain and get an understanding who are the different actors in your supply chain, but only in those high-risk areas. and not in, you don't have to look at a company that is delivering water to your premises that nobody cares about under the CS3D. And right now, under the German Supply Chain Act, everybody is also looking at those suppliers. So it's a much more risk-based approach.
But on that particular approach, just to be clear, nothing changed in the latest version of the CSDDD, right? That approach was already there in that
Correct.
way in the trial outcomes in December.
Right, right.
All right, then let's maybe take again the case study and how can we now conceptualize this scoping for each individual case. Again, let's assume we are a multinational manufacturing company, how we now scoping risks for the upstream parts of our supply chain or the downstream parts of our supply chain. The coffee we have excluded a priori. We are not even scoping them because they are not part of a chain of activities. The legal services company based in supplier based in Germany, we would not consider them to be in scope or of particular risk, neither when it comes to them directly. So that would be tier 1 in scope. So that legal services company in Germany is not directly a risk supplier based on the country risk, the industry risk. And their supply chain, the supply chain of a legal services company, that's what we mean with tier N in scope, would also not be of risk. And also the downstream side from a legal services perspective it's not relevant. On the call center services side, we would consider, based on the country of India and the general risk for human rights abuses that is at least elevated for call center service companies, for them to be in scope on a tier 1 level. So that particular supplier would be in scope. The supply chain of the call center service provider would not be in scope. For the battery supplier based in Vietnam, that is clearly a case where both the company directly, this company producing batteries in Vietnam, would be in scope for further assessment. The supply chain of the batteries company would be in scope for further assessment because they produce or use high-risk materials sourced from high-risk countries, typically from a battery manufacturing perspective. And also the downstream would be in scope, let's say from a waste disposal perspective, or actually, no, that could actually be something that we haven't changed from the latest version. So the waste disposal aspect of the battery supplier would not lead it to be downstream in scope. So maybe that could be an X. Is that correct, Sebastian? Am I correctly interpreting? The downstream of the battery supplier might actually be an X now because of the exclusion of the waste disposal from the downstream part, right? So it could be an X, might still be a check mark, depending on how we scope that. In pre-wave, that is, the scoping is a clear step of the risk assessment process that we also support using a dashboard. That dashboard shows not individual suppliers, but it shows suppliers clustered. So each bubble here would be a cluster based on country and industry combination, could also be a country commodity combination. For instance, here, China and electronics, or as we saw earlier, Vietnam and batteries. These would lead, based on the country and industry risk profile, this cluster to be either further up into the right, into the red, or if it's a uncritical industry in an uncritical country, it would be in the green. And this scoping can be done both on a tier 1 level, so considering the risk of the direct suppliers, but it can also be done on an abstract basis based on the riskiness of the supply chain of a given supplier. So we know that the supply chain of a battery supplier is riskier than the supply chain of a legal services supplier in general. And that is also a scoring we have in pre-wave. and that we can use to scope. And what we then have scoped, we would proceed to map and to make transparent in depth. And we will get to that also at the end of the webinar to make it clear how that process actually looks like. And maybe handing over to you again, Sebastian. Can you explain the nature of involvement in the CSDDD as compared to the German Supply Chain Act? Sebastian, you're on mute.
Okay, yeah, I'm still muted. So under the German Supply Chain Act, the contribution is basically just one of the 4 appropriateness criteria. Under the CS3D, it's more prominent. So the nature of involvement basically decides on the measures you have to take. And maybe we can go to the next slide where it's easier to see that. So under the CS3D, we have to distinguish between 3 different natures of involvement. The first one is you're causing an adverse impact. So you're basically the only company that's causing an adverse impact. Then before we had the definition of contribution, this was changed to caused jointly. Caused jointly is a bit more limited than contribution. And then the third one is causation by another business relationship. So you're basically only directly linked to an adverse impact. And depending on this nature of involvement, you would need to avoid or mitigate, when you look at causation, the adverse impact yourself and entirely. If you're causing jointly, then you just have to avoid or mitigate your own causation. And if you're not the causer, so the causation is by another business relationship, you just need to use and increase your leverage. And in the end, this could mean that because very frequently companies will only be, let's call it, directly linked to a causation. So in the end, they just have to use or increase their leverage. And using and increasing leverage doesn't mean or doesn't necessarily mean that you have to take very far-reaching measures. It's all in particular that you basically tell the actual causer, hey, could you please stop the causation? Could you improve the situation? And I can support you. But it's not that you have to take far-reaching preventive or remedial measures. So that's the logic of involvement under the CS3D.
Greta, maybe you can clarify. Typically, this nature of involvement, if you look at the OECD guidelines and UNGPs, we know it as cause, contribute, or directly linked. Like this is the typical terminology. In the trilogue version or compromise, this was already changed to caused jointly and caused by another business relationship. Is there anything behind that? So did the definition really change, or is it more or less cause, contribute, directly linked, and just the wording changed? Can you give us some insight into that?
It's actually now an entire recital on why we changed the terms, because for some people it's very clear what directly linked means, but of course in a company that never used the OECD framework, it can be confusing that we call it directly linked, although that's the part of the supply chain that you have no control over. So you're actually not in any way directly linked to it. Because here we have causation and contribution, which means that your actions have a relationship to the risk that you're assessing, while everything else in the supply chain is called directly linked. And it was just about the fact that this term can be confusing. We're trying to clarify that causation is something that you're entirely responsible for. So usually this happens within your own company or with your own business actions. Then caused jointly is essentially the same thing that we used to define as contribution. So something that you cause together with another business relationship. And anything else is just caused by another business relationship, meaning it has nothing to do with you.
All right, and then Greta, maybe you can tell us what, if anything, has changed as it relates to the climate plan and the financial sector inclusion, something that I also saw a question about earlier.
Yes, the climate plans were originally designed to have an objective for companies to fulfill the Paris Agreement. In the end, the current compromise basically just says you should adopt a climate plan. But if you already do the CSRD, so especially the European companies falling under this directive, they already fall under the reporting directive. And so they're already reporting on their emissions, and the reporting is enough to fulfill the transition plan. So what we say is if you do CSRD properly, you already fulfill the transition plan. Now, it just not only says you should adopt, but you should also, I think, try best efforts to implement the plan. But this part actually is not, supervised in any way by enforcement. So you cannot be sanctioned by how you implement those targets, and there's no control over it. So this is, to me, this is window dressing because you fulfill the adoption of the plan with the CSRD. And even though it says you should take further actions as an obligation of means to try to reach those specific targets of the Paris Agreement, there's no enforcement behind it. So basically, you could just as well not do it. Another point that was connected to this plan were financial incentives, so the so-called variable remuneration, which in practice is basically bonuses for directors that for the very largest companies should have been linked to the plan. So if you don't have any targets or you don't fulfill them, this should have an effect on the variable remuneration of the board of directors. This was already limited to being a voluntary scheme, but now in the latest version, this part was completely deleted. So in the entire directive, we're not talking about directors anymore. We're not talking about directors' duties anymore. There's nothing with financial incentives. All of this was deleted.
Mm-hmm. And the financial services sector, again, just to be very explicit, they are still in scope when it comes to them procuring any kind of material they need, IT services, anything else they might need. Whether that is now a risk or not is a different question, but they are not at all in scope for any of their downstream activities, which would be anything they do towards their customers. So lending, financial services like credits, investment advice, anything like that would be completely out of scope for financial services companies. Great, just to clarify that. All right, then with 7 minutes left, we will give a short look on the implementation timeline. So just for German companies that are already under the LKSG, but also companies that are new to the CSDDD, which due diligence obligations that companies are now facing take longer time to implement, also based on the experiences we already have seen from the German supply chain law, and which are the topics that companies should start earliest. And I guess, Sebastian, one of the first things they will start, and you told me earlier they have already started, is to check whether they're actually in scope of the CSDDD, right? So that should be point
Yeah,
zero.
while the two of you were talking, I was looking at the questions, and we have 109 open questions, and I guess half of them refer to the scope of application. Whether you add up numbers to the parent company and who basically in a group falls under the CSDDD. So of course that would be the first step, whether you already fall under the German Supply Chain Act or not, to assess whether you fall under the CSDDD. And then it depends a little bit on the timeline when to start, whether you already fall under the German Supply Chain Act or not. If you already fall under the German Supply Chain Act, you will have a lot of measures and processes already in place that help you to fulfill the CSDDD. So maybe you will need less time then. Anyway, one of the most important things after assessing the scope of application, and if you're pretty sure that you will fall under the CSDDD and maybe also fall under the German Supply Chain Act, is to do this scoping exercise of the CSDDD and assess whether you have high risk supply chains, which you would then in a first step need to make transparent. Because in order to take any measures in your deeper supply chain, the most important thing is to know who is in that supply chain. So you would, and this basically needs time. Maybe you have some support in getting the data of your deeper supply chain, but if you don't have that, or if it's not available, then you would need to go through your supply chain and ask the supplier who's your pre-supplier, and then ask the pre-supplier who's your pre-supplier, and so on. Mm-hmm. So that's why we mentioned this here at first, the risk assessment for the tier N supplier, and even before that, making transparent the tier N suppliers. Mm-hmm. And then, of course, we here on this overview made a suggestion on how much time you would need for all those due diligence obligations mentioned in the CSDDD and the German Supply Chain Act.
So maybe to wrap up, to again give an overview of how the implementation of this risk assessment process can work on kind of a step-by-step basis. So the first step again that companies should start with is the scoping, which to repeat is the identification of general areas of risk. And for those that are familiar with the German Supply Chain Act, this is somewhat similar to the abstract risk analysis, but the key difference is that you're not looking at individual suppliers at that step. So the scoping at this particular point can be done based on a higher level. So looking at just a combination of countries and categories, countries or industries, countries and commodities, to say batteries I'm sourcing from Vietnam are generally of higher risk, or I consider in scope. For instance, the legal services I'm procuring from Germany are out of scope. And the difference then for the CSDDD is that the scoping definition needs to be made on the one hand for first tier suppliers. So is my direct supplier based on the industry, the product I'm procuring from them, and also the country where they are operating in, directly at risk. So this is, again, a category country approach, but it relates to the direct production location of that supplier. The tier N scoping relates to the riskiness of the supply chain that's behind that supplier. So you could have cases, and I'm addressing here some questions I saw also during the webinar, where you have suppliers that are actually not in scope on a tier 1 level, but they are in scope on a tier N level. Imagine retailers or wholesalers. Imagine you're procuring batteries for your products from a wholesaler that's based in Germany. The wholesaler itself in Germany might not be of particular risk under the CSDDD, but the products you're procuring and the supply chain that's behind those products is at risk. So that company would be out of scope, that wholesaler would be out of scope on a tier 1 level, but the battery supply chain that you're actually procuring is in scope on a tier N level. So that is just a new concept. But again, we support our customers, our existing customers, but also new companies during this process with a scoping dashboard. That's the first step. As an outcome of the scoping, we have now identified those suppliers that we see as being at risk, that we have prioritized for in-depth assessment. Depending on the tier N scoping, we also map those suppliers. Again, the call center supplier, we are not mapping. I saw some questions that they might be using subcontractors. That could be a reason to also look behind the call center, but let's assume they are not engaged in subcontractor work. They are just employing the workers directly. Then we would not scope the tier N. We would also not map them, but the battery supplier we would map. So we would then run both on the tier 1 level, the call center supplier and the battery supplier, through a risk assessment. In PreWave, that's a 360-degree scoring approach. combining several data points from media screening to country industry risk to the maturity and capacity of the supplier based on available certifications and policies. And the same process would also be run for the tier N suppliers. Again, here with the added difficulty that sending self-assessment requests to tier N suppliers will be very difficult, if not an impossibility, due to the lack of a business relationship you have with those suppliers. So an automated scoring approach is needed. And then we are prioritizing these risk suppliers based on the nature of involvement. So what you saw earlier, cause jointly, or what was the other one? Not directly linked, but as that was called.
Caused by another business relationship.
I'm too involved in the old OECD and UNGPs, so caused by another, which is then prioritized based on the leverage, and based on that you're taking measures. So what you see here is this funnel. This is kind of the risk-based approach. The mapping you do also only in risk areas, and then you only continue working with risk and high-risk suppliers during the appropriate measures. So that is a short summary of the approach that we are also supporting our customers with during the CSDDD implementation. And to end now on the process, again, if you are a medium-sized company with less complex supply chains, you have some time. Yeah, you might as well have a later application period in 2028 or 2029. But for companies that are large, that are in the first cohort or first phase of application with multiple complex or high-risk supply chains, we do recommend to get started with scoping as soon as possible. And we do offer these scoping projects at this point actually for free to our existing customers because we have those suppliers already in the system. And for new customers, you can sign up for a scoping project under this link. We will also share it in the subsequent follow-up email, where we will also share the slides and the recording of that webinar. And with that, we go to Q&A. I believe Greta and Sebastian have already been highly busy on answering questions. We see 72 questions already answered. We will actually also share these answered questions with you in the follow-up email, because we can export them. So we will also get a report. And yeah, Sebastian, you wanted to say something?
Yeah, because maybe an answer that will answer maybe 30 or 40 questions.
Oh,
so a lot of people asked whether you need to look at the individual entity with respect to the thresholds or at the parent company. So in a first step, you look at the individual entity, and then it might be the case that this entity doesn't reach the threshold of, let's say, 1,000 employees and or the threshold of for more than 450 million in turnover. But then in the second step, you also look at the parent company, because in Article 2, it also has a part B, which says if those thresholds are not met on the subsidiary level, on the entity level, then it might still be the case that the ultimate parent company of a group that reaches those thresholds falls under the CSDDD. So while a lot of companies might not reach the thresholds on the entity level, they may reach the thresholds when they look at the parent company. Mm-hmm. And then the next question would be, what does the parent company then has to do? And right now, when you look at Article 6, then of course, again, there is some room to argue what does it actually mean, but it says that the company falling under the CSDDD, in that case, the parent company, would need to look at their own operations, those of their subsidiaries, and their chains of activities. So the parent company then would also need to, with respect to the CS3D, look at all the subsidiaries and the chain of activities. I think that's important to mention, and a lot of people asked that in the Q&A section.
Another kind of theme, and maybe I think at this point we can only address themes we see in the Q&As and not individual questions, is again this interrelationship between the CSDDD and the CSRD. I think some questions I saw is, so is the CSRD now already fulfilling the CSDDD? It's the report. Maybe you can again clarify that, Sebastian.
So the CSRD, it's just a reporting obligation. So the CSRD in the ESRS says you need to report on your supply chain activities. For example, do you have policies in place with respect to your suppliers? However, under the CSRD, you could also say no, and then there wouldn't be any penalty for writing no. So if you fall under the CSRD already in, let's say, 2026, but you don't fall under the CS3D yet, then you could still say under the CSRD, okay, I don't have that policies in place. As soon as you also fall under the CS3D, then you would need to report what you have done under the CS3D in the CSRD. So then you couldn't write no anymore. Then you would need to describe the processes you implemented under the CS3D, under the CSRD. So this also means if you fall under the CSRD before you fall under the CS3D, you don't have to implement the CS3D in advance. You could still go with your processes that are not that developed, that you are currently developing under the CSRD. But as soon as you also fall under the CS3D, then your reporting obligations under the CSRD will be broader.
Okay, great. Thanks, Sebastian. Another general theme I want to quickly address is the question again around the scoping and how does this work? I also saw one question. Does the scoping, is it similar to the double materiality assessment of the CSRD? And here, clearly no. Maybe it's quite similar in that you have to do it first before you proceed. I mean, maybe in that way it's similar, but no, in terms of content, the double materiality assessment is very different. The scoping is purely based on risk, and it actually also doesn't consider spend or any other additional criteria. And the CSDDD is quite explicit. It's a purely risk-based approach. So you scope and prioritize based on the likelihood of risks. And what risks? There was also a question. What are you looking at? There was a person asking, is this now cyber risks? So the risks that you are considering are laid out in the annex of the CSDDD, and they are human rights and environmental risks, and quite actually an extensive catalog based on ILO conventions and many other human rights conventions. Think for child labor, forced labor, and on the environmental side, it's also very broad, going into topics like biodiversity, deforestation, and the like. And maybe last question, how does the scoping work? So a person asked, how can I transfer my supply chain now into this approach? So again, for previous customers, that is a very straightforward process. We simply use the suppliers we already have. For new customers or companies that are looking to start, we just need a list of your tier 1 suppliers. We don't need a sub-suppliers. We just need a list of tier 1 suppliers, and actually only those that we already consider part of this chain of activities. Yeah, so we don't need your coffee supplier for the kitchen. We need already a set of suppliers that are directly related to the products and services that you provide. And based on that, we can do both the tier 1 and tier N scoping out of the box. And that's a 1 to 2 month process, so very fast. And then you know where to map. And there's also a question that I want to address here in the that is also a very recurring theme. So when mapping supply chains, no supplier will share their suppliers. So how do we do that? The mapping we offer at Prewave is a public data first mapping. So we proceed with the mapping by using publicly available customs data, media data, and only then we can already reach a very high level of transparency, and only then to validate where necessary we approach the supplier, but we don't ask them to proactively share suppliers from the get-go. Sebastian, Greta, did you identify any other questions or themes you want to address?
I mean, I think there are a lot. We can try our best. You can always also, I guess, contact us with further specific questions. One question that I saw is, where can you find the text? The text is not officially published yet. I think it's going around quite well, but if you're still looking for it, it's actually on the LinkedIn page of Axel Voss.
Okay. Great. Sebastian, from your side, anything you would still like to address in the Q&A?
Maybe there's one. How will the CS3D affect indirect suppliers? So, I mean, that's a question we receive a lot also under the German Supply Chain Act. And indeed, the smaller companies not falling under the scope of these regulations, they are definitely also affected because they are receiving new demands of bigger customers. And this in the end, so is a question on what's the best way to react. And this, of course, depends on your market power. So are you actually able to say no to a big customer, or do you have to fill out the questionnaire of the customer? Do you have to provide the information, because otherwise the customer will just switch the supplier? If that's not the case, of course, you could play back the ball to the customer, and if the customer has a lot of requirements or asks you to fill out questionnaires, you could say, well, I can do that, but first I want to have an explanation why you consider me being a risky supplier. So please provide me with the results of your risk analysis. At least that's what the BAFA, the Authority for the German Supply Chain Act, published in their handout on how to behave with suppliers, that suppliers should ask for explanations and not provide general information which are sent to all the suppliers. But of course, this depends on your market power. And in the end, if you are a smaller company that receives a lot of these questionnaires, a lot of questions, you could think about, or the problem is that some of these companies are basically also thinking about doing a or taking certain measures on their own, like having a person responsible for all these topics in the company, or conducting risk analysis on their own. So let's see how this develops, but we can definitely see an impact on the smaller companies as well. Or another aspect is that a lot of smaller companies, they now do these rankings, ESG rankings, because this is also something that they can provide their customers with. And a lot of customers, if they can see, okay, the ranking is really good, then they will not ask further questions. But definitely we can see this trickle down effect through the entire supply chain.
All right. Okay, thank you, Sebastian, and thank you so much, Greta, for joining this webinar. I think it was highly informative and packed with information. To everybody in the audience. So you will receive a follow-up email probably during the course of tomorrow, with the slides, the video, the Q&A that we answered in writing, and we might also attach the text of the CSDDD. And I can also assure you this was not the last webinar, but probably just the beginning of a series of webinars around this and many other topics. Greta, Sebastian, thank you so much, and everybody.
Thank you.
Thank you.
All right. Bye-bye.
Bye-bye.
Take care. Bye.